From Railway Factory, Yelahanka. Very glad that I got this opportunity at Trivandrum Railway Hospital. We have PPT divided into two sessions, one covering the Act, rather a familiarization with the provisions of the Act. Second one will cover case laws, which have a practical application with day-to-day dealing of RTA cases. Here we have a screen also actually, but those who are online, we are sharing the PPT. Because this is a railway platform, I wish to start with an anecdote, which I normally tell on all training sessions. Probably, I feel that many might have not filed applications, I mean RTA applications, and from my experience, many join the training sessions with an idea, with a plan to get some glue or some weapons to negate the RTA queries or applications. Here, actually, I must put a word of caution. At the very outset, government wants us to share the information, part with the information. So as Supreme Court has already laid down, furnishing information should be the rule and denial should be an exception. So while denying, we should be very cautious. Before denying, we should keep in our mind, is it worth taking the risk? Because I have seen many get carried away by the repercussions of parting with information. Some feel that this may result into a litigation, some case may come up, all those things. But let us face all those things. Let us not get carried away by all these considerations, because section 6(2) of RTA says that the applicants need not give any reason at all. So my view is that to the extent possible, let us share information and be safe. Because if in the event, if any penalty is imposed, it is a CPIO who is going to pay from his pocket. So that difficulty is there. And there is a possibility that they may take up under discipline proceedings also. So with all these things, it is not normally normal course, unless any information is falling clearly under section 8 or 9, let us not decline information. But as I already told, many join the session with an idea that how to get some weapons or ideas to decline information. Many join training sessions with that concept actually. So actually, as I already told, I would like to put an anecdote before you, because this is a railway platform. One day, lion, king of jungle, forest, happened to spot a rabbit. So the lion chased it. Unfortunately, lion could not catch the rabbit. The lion felt very embarrassed because lion is a king. Second day, again the same lion happened to spot the same rabbit. Second day also the lion failed. Still felt bad. Third day again the same thing happened. Actually, the lion was not in a position to swallow the pride or failure. So the fourth day, when the lion spotted the rabbit, lion asked, "Don't run today, I'm not going to chase you. But let me know why I was not able to catch you. Because I am known for my speed. I'm known for my speed, but with all those things, speed, might, and all those things, I could not catch a small animal like you. Can you tell why this has happened?" Then the rabbit asked, "Why did you chase me, lord?" And lion told, "Naturally for my breakfast." "O king, you were chasing me for your breakfast, but I was running for my life." "You were chasing me for your breakfast, but I was running for my life." Why I tell this is, let us not deal RTA cases as a mere dealer of RTA. Let us raise our level to RTA applicants, because normally RTA applicants are well equipped. We don't take the pain to update ourselves. keep abreast of the latest developments. But whereas the RTA applicant is normally knowing all the nuances, current trend, latest rulings of the court, all those things. So our effort should be to reach the level of RTA applicant, not merely to relegate or confine to the standard of an RTA dealer. So that is my request here. So my effort here will be to make you to give some idea so that you will be sufficiently equipped to even act as a RTA applicant. As Supreme Court has told, it is known as a Sunshine Act. That is what Supreme Court has told. It has changed many things. It is having wide repercussion in the social scenario. You can bring in so many things. You can plug corruption, bring transparency and all those things. Actually, I don't want to further prolong into the introduction. So let us go into the training. There are, as I told, there are 2 sessions. One regarding the familiarization of the RTA Act. So we must know basically the Act. Once we get acquainted with the provisions of the Act, next we will go to the case laws. Case laws means what we have general doubts. Suppose an advocate is applying what to do, a company is applying what to do, there is no signature, there is no fees. All those things are actually doubtful for us. Somebody is asking personal information, what is third party? So many things are there. Is there any other exception other than what is stated in section 8? So all those things will come in the next slide. Actually, the material what I am having is meant for 2 days training. But we have to rush in another about almost 2.5 hours. We have to wind up. So some slides I will be skipping, and some slides we may not go through the entire one. But of course, with all those things, we will be having an interactive session. Whichever doubt you are having, you can anyhow. How many of you have dealt with have applied RTA? How many of you applied RTA? 1. Okay, good. Okay, no problem. So this you can use actually. RTA can be used in a positive way to bring in some changes, stop corruption and all those things. Now we'll go to the purpose. Here you have mouse, sir. Mouse to change the slide. Mouse. Okay, now the purpose of RTA. All of you are dealing with RTA or just to fill in numbers? How many of you are dealing with RTA? All are dealing? No. Okay. RTA was enacted to allow access to the information held by public authorities. The purpose of RTA is to ensure that public are given access to the information held by public authorities. That is a purpose. Then object, why it was enacted. 2 things are actually, in fact, 2 things are there. One is to promote transparency. In government dealings, let us have transparency. That is one purpose. Another one is to have accountability. That is one purpose. Next one is for the constitution of CIC and SIC, Central Information Commission and State Information Commission. So this is a purpose actually. When we go through RTA, we must also know what are all related topics. Earlier, as you see in the slides, we used to have RTA regulation of fee and cost rules 2005 as well as CIC appeal procedure rules. 2 things were there in 2005, as you see on the left side under section 27. Both were framed under section 27. Subsequently, in 2012, both got merged and we have RTA rules 2012. As you see on the screen, fee and cost rules 2005 and CIC appeal procedure rules, all those things got clubbed and we have presently RTA rules 2012. In addition to RTA Act, I'm telling. RTA Act was framed by the Parliament. Rules were framed by the central government under the power given under the Act. That is the difference between an Act and a rule. And earlier we used to have under section 12, we used to have regulations which were framed by earlier we used to have regulation also, but High Court, Delhi High Court had passed the regulations in toto. Now we do not have any regulations at all. You may want, just for information, actually the validity of RT Act was challenged before the Supreme Court. When Supreme Court has told that as per the entry 12 of union list, sorry, concurrent list, central government is sufficiently empowered. As you may see, public acts and records and judicial proceedings under this RT Act can be framed, formulated by the government. So it was done. And we must also keep in mind that RT Act is a fundamental right now, just like any other things, because Supreme Court has linked RT Act to right to freedom of speech and expression, Article 19(1)(a). The Supreme Court has linked this with Article 19(1)(a). So now it is having the status of a fundamental right. So when we are declining it, we should be doubly cautious. What are we doing it? Of RT Act we will skip actually because it takes time. We are running short of time. Just for information, when did RT Act come into force? Actually, it came in force on 15th June 2005. Some provisions. And rest of the provisions, important provisions, all came into effect on 12th October 2005. That was on the 120th day. 120th day, the remaining provisions of RTA came into effect. This also will skip because next slide is concerning how comparison with other countries. We'll skip it. Now coming to the RTA Act, we have 6 chapters, 31 sections divided into 6 chapters. We are not much bothered about chapter 3 and 4. Chapter 3 and 4 deals with CIC, constitution, their powers, election, resignation, etc., removal and all those things. 3 and 4. 4 deals with State Information Commission. So we will ignore both these. Whatever I have highlighted on red color, only we are interested only in those sections. So in chapter 1, we have definitions. That is section 2 deals with definitions. Definitions are important. Then entire chapter 2 is very important. Then in chapter 5, powers, appeals, penalties, etc. are laid down. In chapter 6, only 3 provisions or 3 sections are important, 22 to 24. And as you see at the end, you can see 2 schedules are there. RT Act has 2 schedules also. First one, we are not worried. It is a form of oath for information commissioners. And schedule 2 deals with list of exempted security and intelligence organizations like, say, BSF, RAW, all those things are not kept under the purview of RT Act. In other words, those organizations do not come under the ambit or purview of the RT Act. We cannot seek information from them. Of course, still then we have limited access that we'll discuss later. How far we are having access to this one. Extent of RT Act. Now, actually, this state of J&K and all not applicable. The whole of India comes under the ambit of RT Act. Now, who is entitled for information? Sir, a minute. ഇത് നേരത്തെ വന്ന സ്ലൈഡ് മാറിയിട്ടുണ്ടല്ലോ, ഒന്ന് കാണിക്കാം. ഇത് വരുന്നപ്പോൾ എനിക്കൊരു ഐഡിയ കിട്ടും ഞാൻ എവിടെ ഇരിക്കുന്നത്. Actually, section 3 says that citizens are entitled. Citizens are entitled, but not legal persons. That means company, partnership firm, etc. cannot ask information in their official capacity. A company cannot ask information. It is restricted or confined only to citizens of India. But again, we must also understand that citizens, though the word used is citizens in section 3, Supreme Court has ruled that all persons are entitled. Because in section 6 starts with the word a person. ഇവിടെ കാണുന്നതാണ് ഞാൻ പറഞ്ഞത്. ഇവിടെ നേരത്തെ എൻ്റെ സ്ക്രീൻ കണ്ട ഒന്ന് മാറ്റി തരാമോ? ആ സ്ക്രീനിൽ എനിക്കൊരു ഐഡിയ ആയിട്ട് ഞാൻ ഇവിടെ ഇരിക്കുന്നത്. So Supreme Court has ruled that all persons are entitled. In other words, for example, a foreigner is settled here or doing some job here or something, he can also access information. So it is not merely confined to Indian citizens. That is what I mean. All persons are entitled. Some 2-3 important definitions we need to go through. One is, what is information? Information means, just we'll rush through the definition. Material in any form, including records, documents, memos, emails, opinions, advices, press releases, circulars, orders, logbooks, so almost everything. And lastly, you may see data material held in electronic form. That means whatever stored in a computer or such devices, similar devices, those things also are defined under definition of information. And you may wonder, some information where public authority have access to private bodies. For example, a private school is required to report the strength of teaching staff, their qualifications, salary, etc. To say, for example, to the DEO concerned district education officer. Such information can be accessed through the public authority. So say for a similar thing is cooperative societies. Cooperative societies, they need to report to cooperative societies registrar yearly. So those information which are required to be reported by private authorities to public authority also can be accessed by RTA. That is the last portion of the definition. And we must be very middle. So another thing is file notings. File notings do come under the purview of RTA, because in the early years, Department of Personnel and Training was opposing parting with information of file notings. Then there was a tussle between the CAC and DOPT. Subsequently, CAC has very strictly told that you need to furnish information contained in file notings also. So file notings are not exempted. File notings also come under the definition of information. Definition of record. Actually, the definition of record, as you see, is overlapping with earlier definition. Earlier definition, when you have seen information, there was a word documents, data material, but here also record is having the same definition. Any document. So it is a repetition, manuscript, film, or any microfilm, etc., facsimile, any reproduction of image. Lastly, you may see any other material produced by a computer or any other device. That is data material. So all these things also come under the purview of RTA. The next what we need to see is, what is right to information? Right to information comes under the definition, sections 2J. Very important definition we need to know, because the scope of RTA is much more than what we understand. We may be under the impression that we can pay for something, get some documents. No, it is not that. RTA, scope of RTA is much more than that. RTA means the right to information accessible under this act. Which is held by or under the control of any public authority. This red ink, what I have shown in red ink, is very important here. When we are asking for information, it should be under the control of any public authority or held by him. This is very essential. As we go ahead, we'll get more clarity, but this red colored one is very important when we are asking for information. Then you may wonder, actually, see, inspection of work, documents and records. Inspection of work, documents and records. So that means if some government work is going on, we have access under RTA, we can go and inspect actually. Of course, there are limitations in it, but inspection of work is possible, and we can go and inspect some documents and records, not merely getting some documents. It's not that I send some application by post, I get in reply by post or through online. No. We can go to some office and verify the records or documents also. Then from those documents and records, we are empowered to take extract or certified copies. This is also possible. Then certified sample of material. Suppose I have a doubt whether my uniform is of sufficient quality supplied by a government organization. I can ask for a copy of the uniform clothing. I must pay for it actual cost, and I can send for some lab or something to identify the quality. So this is also possible. And another thing as we are seeing on the fourth one, we can get information in disk floppies, not only in document, we can get information in disk floppies, etc. And there is a widespread confusion about actually public authority and public information officer. Let us clarify it on the next slide. Public authority is actually nothing but an office or a department or a ministry, something like that. Whereas public information officer is a genus of it, species and genus like that. So you just see the definition. Public authority is defined in section 2H, but whereas public information officer is defined in section 2C or M. C is CPIO and M is SPIO, State Public Information Officer. And here one word I wish to put before you. CPIO and PIO are one and the same. Let us not have any confusion about it. Colloquially or locally, we normally tell PIO. PIO is nothing but CPIO as far as central government is concerned. As far as state government is concerned, it is SPIO, State Public Information Officer. In short, we call it as PIO. So don't think that CPIO and PIO are two different entities. Both are one and the same. Normally day-to-day usage we use as PIO, that's all. But it is nothing but CPIO. APIO is different. We'll come to that. What is APIO? We'll see later. Here, as you see on the slide, any authority, body, or institution of self-government established or constituted under the Constitution of India. So any constitutional body or organization, then any department or ministry made through the parliament, by the parliament through any law, same thing by the state legislature or by notification of the appropriate government, all those things, including NGOs. You must see the last. So PA, public authority is a genus, whereas PIO is a species. Refers to that officers who are designated as PIOs. So let us understand the difference.
Substantially, what is substantial?
In some cases, some NGOs are funded by the government, sir.
Substantial is what percentage?
No, that is nothing like that. Actually, there is no clear demarcation.
We have a science student. It's not fully funded by government. It's substantially. What is it? 80%, 70%?
Nothing, sir. Nothing is.
The law has to be very clear. Substantially is.
This is a vague usage. I accept, sir. It is a vague usage. Substantially, the word substantially has not been defined.
Whatever substantial for you may not be total for me.
Correct, sir.
90 by 80%.
Correct.
There are some. We have to ask some information website. This is medical science is there. So that's funded by, established by an act of parliament, funded by government, but not fully. But again, 80%. But can we ask?
Let us make an effort, sir, because substantially is not defined. Once they decline it, we can carry the matter to first appeal and then to the second appellate authority.
All NGOs, almost all NGOs, they have some aid they will receive from government. Indirectly, directly. That's what you mentioned, directly, indirectly.
Yes.
For example, if you're giving tax exemption, that amount is giving assistance only.
Correct, sir.
So that is the case, then they should part of information.
Yes, sir.
NGOs know that important.
Yes, sir.
NGOs now they refuse to give information.
Yes, sir.
They are not covered.
NGOs are now they are required when they are receiving fund either directly or indirectly. They are supposed to give information.
Two places I mentioned. Anybody who won't control a substantially finance, but then too substantial, there has to be some kind of clarity.
Substantially finance, as of now, there is no definition, sir. It is.
Finance, that was finance, finance, we cannot take it. Very good. Finance has to be definitely.
Probably as time pass by, we may get more clarity. As of now, there is no definition of what should be the percentage of funding or something. Nothing, sir. Now we'll quickly see a flow chart. First is section 3, citizens' right to information. Below that, we'll ignore the right side one because this concerns the state. Left hand side, you'll see central government. So under the act, we have central government. Central government has framed all, will take care of all those things. That is constitution of CIC, education programs, making rules. We have seen this RTA rules 2012, framed under section 12. So make rules Those rules should be laid before the parliament, all those things. So below central government, we have CIC. CIC acts as second appellate authority. Second appeal goes to and also of course complaints under section 18 also. So CIC comes, CIC is the terms and conditions 13 and removal and all 14, we are not much interested. Their powers 18, 19, 20 and prepare annual report. These three are the functions. Of course, 25 we are not interested. And below CIC we have public authority. What I earlier told us, offices or departments, ministries, etc. Public authority, their duty, one duty is proactive disclosure. Section 4 says proactive disclosure. That means without waiting anybody to ask the information, part with information to the maximum extent possible so that the usage of RTA is minimized. People's necessity to access RTA is minimized. So you publish in the website, etc. Whichever method you find, you please part with information, suo motu. That is called proactive disclosure under section 4. And below public authority, you may see first appellate authority is there. First appellate authority hears appeal. If somebody is not satisfied with the RTA reply of the PAO or no reply, then he approaches first appellate authority. So below first appellate authority, we have CPAO. CPAO's functions are given in that box: giving assistance to applicants, receive applications, dispose of, and of course 8 and 9. He can invoke 8 and 9 to decline information. 10 is about severable information, that is, which some portion is exempted, some are not exempted. So they are supposed to give the information which are not covered. Then section 11, third party information. So below PIOs, we have Assistant Public Information Officer, CAPIOs. Their task is only one thing: collect the applications or appeals, transmit it to the concerned authority. Nothing more, nothing less. Let us be very, very clear. Anything other than this is not permitted. If anybody is doing, we were actually seeing many officers signing as APIOs and all those things. If it is there, please stop it. APIOs are not authorized to sign, even after getting approval on file. Even after getting the approval of PIO on file, also APIO is not supposed to sign and dispose. Let us be very clear. This power of PIO cannot be delegated further. PIO should exercise his duty for himself. Nobody else can do it. So he has to only collect the applications and appeal forward to the concerned appellate authority or to the public information officer. That much only. His role is only that much, nothing more.
Finished the control,
Sir? Which one, sir? RTA Act. Act, of course. This. Yes. Then we have public obligations of public authorities. What is to be done by public authorities? Section 4, actually, this is so many things are there. Maintenance of records, its update, suo motu disclosure, all those things are there about their library facilities, their what you call concessions, all those things will come here. We need not go into it. We have a time constraint, as I already told. Their budget allocation, subsidiary programs, all those things. Then PIO's name and designation, all those things should be there in the website. And as you see in the last one, update these publications annually. It is not that you just put it in the website and keep quiet. No, you need to update those information annually. Once in a year, at least, we need to update. Here we will see some very important things. You may see section 4.1d, the second bullet. Provide reasons for its administrative quasi-judicial decisions to affected persons. Actually, as even when you deal with disciplinary DR proceedings and all those things, it is well settled that the order needs to be speaking order, whichever passed by the disciplinary authority or the appellate authority or the revising authority. There are so many rulings, right from Supreme Court to down the tribunals. But strangely, this is one place I have seen where the law is telling that is required. The necessity of speaking order is actually evolved through the rulings of courts. But a statute telling that speaking order should be passed, I find only here actually. And here, of course, though it is told in a different context, but it says that administrative quasi-decision should be disposed of through reasoning. This is one thing. Essentials of RTA request. What should be there in an RTA request? What are the essentials? There is no specific pro forma. That means we can apply in a plain paper, there is no pro forma. But in writing or through electronic means, in English, Hindi or official language. So applicant has three choices. Please mind it, this is a choice given to the RTA applicant, not to the PIO. PIO needs to reply in the same language. In whichever language the applicant is asking, I know some problem may be there in some areas, but as per the act and as per the CIC ruling, the reply should go in the same language. Hindi question is there or RTA request is there, we cannot reply in English. As per the ruling of CIC, we'll see it later. Then applicant's name and address definitely should be there because then only we can send the information back. Then the public information officer, whom we are asking, that should be mentioned. Particulars of information required. What is the information we are seeking? That should be mentioned. Indicate urgency if any under section 7.1 because matters related to life and liberty, these two things, there is a very short time limit to dispose, just 48 hours. RTA queries related to life and liberty, we have very limited time, only 48 hours time is there for disposal of RTA queries. So if any such urgency is there, we need to mention it. Suppose somebody has been taken into illegal custody, we are asking the police under RTA Act. They need to reply in 48 hours. So we must tell that there is urgency under section 7.1 because you have arrested so and so person illegally at so and so time or something like that. There should be a description and what is urgency you must tell. Proof of payment. There should be proof of payment that we'll see later. Then it should be signed. Invariably it should be signed other than online applications. If the applicant is BPL card holder, below poverty line card holder, then he needs to give the information about this. And penultimately, we will see an important thing. The RTA request should be limited to 500 words. But in the same breath, it is told that if it exceeds 500 words, it shall not be a reason to decline it also. It is in the form of a guideline. It is not binding on the RTA applicant. What they are telling is 500 words, but even if it is exceeding 500, please don't decline the information. Then last, very important one, no need to give reasons for seeking information. RTA applicant is not bound to furnish any information for seeking. This is very important for PA also. Many a time, we imagine what is going to happen if this is furnished and get carried away. And the applicant is not required to furnish information. Why should we bother about it? What is he going to do with it? Because we get biased and get carried away. No, he is already having a grievance. Now he is asking under RTA Act, he may file a case. Let him file a case. There is a mechanism, machinery to deal with it. Let us not worry about the future happening. And decline an information which needs to be parted with, provided, and attract penalty or dispute proceedings. Let us be safe now. If the information needs to be furnished now, it is not exempted, please furnish it. Don't think of the consequences of parting with information because you are trying to deal with an imaginary situation which may or may not happen. He may or may not file a litigation. But if you decline information which is to be given, as on this date, we are going to attract penalty, get penalized. So let us not take a risk which is certain for a possible threat. If any litigation comes or anything, we can deal with it. That is a different issue. So these are the requirements about RTA application.
Someone asked that email. Request an email.
How he will pay, sir?
Postal order check, whatever it is, will do it.
How do you connect it, sir?
Payment only issue, no? Payment is not an issue. Then without payment also, is there sometimes can someone ask under email, on email, that's what electronically. Message send it all information we have, so many TVs, videos, everything. We submit it. It is stored in electronic form.
So the electronic, if it is formed in a, if it is stored in electronic form, we need to definitely part with information.
Can you submit any application on email? Official email ID, can someone access, can easily can submit information? Is it there now, sir? Has someone taken up that issue?
No, sir. Actually, this has never come to our notice, but
But you are saying name and address. Email will not contain name and address. Email you can say.
no, sir. Email also one can furnish, provide the name and information. But somebody asking information through email, I have not seen, because along with email there is no provision to pay. Because of that reason, so far people have not seen never using email. There is no mechanism to pay the fees along with the email.
He is not sending money. He is only sending the postal order. Postal order, you can produce a copy that can be attached to it. And if he comes by post. Then is not the payment part. The payment part you can send to. Can someone request on email?
Technically speaking, there cannot be any prohibition for asking him through email.
Right now, since
Because as per the IT Information Technology Act, whatever is needed to be in writing or signed can be sent through email, etc. Electronic communication is sufficient.
In other words, can we refuse if somebody asks an email? Can we refuse?
Only if there is no payment, sir. Actually,
that's all.
Only if there is no accompanying payment, then we can decline it. But again, payment also we'll see. CAS is selling.
The payment is possible now. It's all electronic money. Government is encouraging digital.
No, sir. Actually, when no payment is there, there is a question. Actually, we'll see it. Actually, CAC has ruled in some cases that even without payment, you need to furnish information. We'll come to that slide when we are dealing with the cases.
Specifically mentioning name and signature. That's it. Because we are not there email.
No, signature is not required, because even RTA, MIS, and all, we are dealing with application without any signature. Because the purpose of signature is fulfilled when he is sending through online. That is deemed. There is no problem for that. Then transfer of RTA request. Here also there is a confusion actually. Transfer is concerned. Transfer is always between the public authorities, not between the PIOs. One public information officer to another public information, there is no question of transferring. It is only between the officers or departments. In other words, it is only between the public authorities. Suppose CMS is receiving a RTA request. CMS, suppose if he is marking to senior MS or SAMS for furnishing information to him, which is under those officers' custody, that is not transfer. That is only seeking the assistance from another officer. Section 5 is attracted, not Section 6. Section 6 is transfer between the public authorities. So let us be very clear about it. Don't put to somebody who is in the same office and tell that I have transferred to you. We have seen applications wherein the recipient officer transfers to somebody in the same office, something asking him to directly dispose of and all those things. So it is not possible unless somebody is nodal officer and he marks to PIO. It is different issue. But PIO seeking a subordinate officer or somebody for information, there is no question of it. It cannot be treated as transfer. That particular officer who will be deemed as PIO in the event of a violation, breach of RTA provision. Suppose ACMS is asking senior MS some information which is kept with him. Senior MS fails to furnish information. Here in this case, senior MS will be considered as a deemed PIO. And if there is a breach of time to furnish or no reply, penalty will go to the senior MS because he is treated as deemed PIO. So only to that extent.
How do you defend if public authority, if DRM of India or hospital is everything is a public authority or each department is a public authority?
Very difficult, sir. Actually, this is a gray area. To be frank, this is a gray area. Only my this one is mostly in suppose a divisional office, a random divisional office.
As the definition mentioned, the PIO is a public authority. PIO is a public authority.
No, PIO is not a public authority. PIO is an officer designated as such in a public authority.
Department is non-existent. Particular person.
No, sir. Actually, here a public authority concept is office, ministry, department, something like that. Or maybe a field office or something. Very difficult, sir, actually, to distinguish. But my personal point is actually this is not defined or this is not so far clarified.
Public authority, you can transfer the
Yes, sir. But what I suggest normally is that you different offices situated at different places, please treat it as a public authority, different public authorities.
Suppose the information start from CMS and that is available in the operating department, for example. That's to be done. We say that we don't have, or we can transfer it to operating department information.
Here two options are there, sir. First thing, an RTA applicant is bound to apply to the concerned public authority. That is what his act is telling. So if it is wrongly addressed, you can decline the information, saying that I am not the custodian. Yes, that is one option. One option is you can decline straight away because I am not the public authority who is.
Where it's available.
If it is known to us, we will tell. Okay, it is with CNADOM, not with this office, or it is with CNADSM, not with us. We can tell that. Next option is, as CAC suggested once, if this can be transferred easily and inexpensively, that is what the word used by CAC, then please do it. Say electronic exchange or through email or something, we can transfer to somebody, or through RTA MIS or something. If we are able to transfer it, please transfer to the concerned authority, is what CAC has given as a guideline. CAC has told you are at liberty to decline it because the applicant should exercise sufficient prudence to apply it to the concerned public authority. So that option is there, sir. So here, transfer of RTA request, it is only between the public authorities and never between the PAOs. Of course, we will see a case wherein public information officer to information officer was also done. But in the event if it is transferred to another public authority, the recipient officer should inform the applicant that your application has been transferred to so and so public authority. So you can communicate directly with him. Then RTA online. We have RTA online portal also, RTA MIS and all. So now everything is digitized. We can submit our RTA application, first appeal and second appeal also. Earlier second appeal was not there, now second appeal also got introduced. Everything can go online. Fees also can be paid. There will be a link there. We can apply online and pay there and get our applications dealt. And payment, mode of payment. The recognized methods are cash against receipt is possible. Suppose railway cash office, you can go pay 10 rupees or whatever it is, produce a receipt along with the RTA application. This is one option. Otherwise, you can give DD or bank check or postal order. These three other or electronic means. Through credit card, fund transfer or something if you are applying online. These are the methods. Then what all the fees needs to be paid under the RTA Act? First is processing fee under section 6(1). That is what we pay as 10 rupees at the start along with the application. What we furnish is processing fee. That is 10 rupees at present. Thereafter, copying charges and the cost involved for higher sized papers or disk, floppy, all those things we need to give. So under section 7(1) and 7(3), we have two types. 7(1) is about photocopying and all charges. 7(3) deals with getting information print or electronic media like CDs, floppies, etc. And the word used further fees covers only these two, section 7(1) and 7(5). Not any other fees, because in a case what we have cited there, in that case, the PAO has imposed some imaginary costs for manpower, etc., etc. CAC did not agree. CAC told further fees. The word further fees means only the copying charges and the electronic format of information, nothing more than that. So confined only to that extent.
Then the applicant has to show it or the PAO has to show it?
It depends. It depends, sir. Actually, applicant can ask always, but it depends. We need not convert hard copy into digital form and supply him. Suppose something is available in digital form, we'll supply only in digital form. For example, something stored in a system or something, we need not take printout or something. We can give in CDs or whatever it is. On the other hand, suppose some information is available in hard copy, we need not digitize, make it into CD or something, give it. That is it.
If you want to leave it.
Yes.
We do not want to spend paper. We can say that I can make a CD template.
Yes. 50 rupees. Yes.
But we won't want that. That is scanning of all these things. Sometimes the printing is voluminous.
then we can give by, if it is voluminous, we can give in,
Labor also.
yes, sir. Time saves everything,
Time.
yes.
Just copy it.
Voluminous information, if it is available in electronic form, we can write in CD and give it. Now we need to see the RTA processing fees and further fees. Processing fees, as we have seen already, it is only 10 rupees and there is no fees for below poverty line persons. And rule 4 of RTA says, what are the other fees? Rupees 2 per page for A3 and smaller sizes. If it is a bigger page, actual cost, samples also actual cost, and you may see the floppy and disk, rupees 50 per floppy or disk. Information we are writing in a CD or something, it costs 50 rupees per CD. And inspection of records, as we have already discussed, there is a right for the RTA applicant to come and inspect the records. So in that case, first hour is free. First hour we do not charge him anything. We give access to him for 1 hour free. Subsequent hours are part thereof rupees 5 per hour. 5 rupees per hour is what we charge from the second hour onwards. And seventh point is very, very important. Actually, almost everybody is ignoring this vital aspect. We will spend only rupees 50 from our pocket to send the information. Suppose a bulky information, voluminous information, suppose running into 500 pages or something. We need to ask the applicant not only for further fees, we should ask the postal charge in excess of rupees 50. Suppose 500 pages are there. We are weighing it and suppose it is coming to 200 rupees postal charges. Of this 200 rupees postal charges, we are going to pay only 50 rupees. Remaining 150, the applicant should bear. So what we need to do is when we are informing the applicant that there are 500 pages information, we'll ask 500 into 2 rupees, that is 1000 rupees you need to pay. That's 150 rupees towards extra or excess postal charges. Please include that also if it is a bulky information, because we are authorized to spend only up to 50 rupees for postal expenses.
The inspection of records, who did that duration? The fellow who comes, he says, I want to inspect everything, he takes 5 hours, 6 or 10 hours. He is secondary. First to show that custodian.
Somebody, custodian should depute somebody and allow the inspection, sir. There is no other alternative. If he comes and inspects, we'll just note down the time of starting, because definitely our representative should be there. Otherwise, if he is tampering with the information or snatching it, tearing it, we should be cautious actually.
So that is there. I'm talking about spending that much time. For him, 5 rupees, that it's nothing. They will say, I'll spend 10 hours spending something. Whole time spending in the office.
Difficult, sir. Such issues are very difficult to tackle.
Activists no other work for them. 50 rupees, nothing for them. You say that I want some army to go in. I want to see all the whatever.
Difficult.
You will be using manpower.
Yes, yes, sir. Yes.
You will be using manpower.
So you cannot get it over there. So keeps on saying, you show me that, show me this.
That is a difficult, sir, because if the information is voluminous or if he is deliberately consuming time or something, we are helpless.
You have to search it. Because anytime it's difficult to search. If 10 years, I want to see all 10 years, you gave me a record. No problem.
You're asking for 10 years PME records, and actually recently, just before my starting from Bangalore, we have come across a very interesting case in RWF. One BPL card holder has applied for information, 106 items. Very huge information, and each question has each item has sub questions. And in most of the cases, 13 years, some information pertaining to 13 years, some 7 years, some 9 years. 106. What we are doing is very simple. We are telling that this is a frivolous application. This is a reply what we are planning to give. There is a provision we will come across actually, sir. CAC has evolved some other exceptions also other than section 8 and 9. So in that one condition is frivolous, because if we are to furnish this 106 information, it will take months together. Not only 1 month, it may take 5-6 months. That's such a big information he has asked. So frivolous information we can support. Somebody is asking 10 years PME records, means it is actually without any specificity. It is only to trouble. So in some cases we may use this ground as frivolous cases. Now the last one. Of course, when we are asking to pay further fees, we should intimate him the breakup. Suppose 500 pages, we must tell 500 into 2 per page, 2 rupees per page. And the applicant has a right to appeal against the fees also. So when we are asking for further fees itself, we must indicate the first appellate authority's name, not only in the final reply. When we are asking the applicant to pay the further fees, there should be an indication about the first appellate authority along with name, address, phone number, email ID, all those things. So that is very important. And the last one, very important one. If the information is not furnished within the timeline provided, it needs to be furnished free of cost. So my point is, please don't run into this area of giving something free. No, sir, I don't. So let us avoid giving the information free of cost. Let us act within the time and let us not. This is one risk. One risk is we have to give the information free of cost. Second risk is we may be attracting penalty also. Not only that we are going to give it free, but we may be attracting penalty or disciplinary proceedings against us. So please don't run into this one. Exceeding the time limit, please don't do it. If at all there is some difficulty in complying with the timeline, what to do, we'll see. Like interim reply. Assistance of PIO. This is what we were discussing earlier actually. PIO can ask the assistance of anybody, any officer below him, any employee below him. And whenever PIO is asking for assistance, such person shall furnish the information. There is no option for him. This includes first appellate authority also. We'll come to it actually. Anybody PIO is asking, he is bound to furnish the information, including the first appellate authority. Suppose ADRM is a custodian for all passenger amenities or passenger complaints. It is only he is the custodian, let us assume. I think mostly it is the case. ADRM controls the public grievances and all those things. Suppose there is a CNDCM is getting an information, RT application which deals with this one. So CNDCM can ask ADRM. Actually, CNDCM is PIO, but ADRM is separate authority. But in this context, ADRM becomes only the officer whose assistance has been sought. He will not have that status of first appellate authority or something. ADRM has to give information to PIO CNDCM for parting with the information to the RT applicant. The third point is the officer whose assistance is held liable under the RT Act because he is treated as deemed PIO. So any violation of RT Act, he will be held responsible and penalty imposed accordingly. Last point, just now we discussed. PIO cannot ask somebody. Suppose PIO is receiving an application, he cannot forward it to somebody asking him to directly reply to the applicant. That is wrong procedure. There is no such option for the PIO. PIO can seek information, get the information back, apply his mind. Do not act as post box. That is what CAC has told. Do not act as post box and mechanically forward it back to the applicant. PIO has to apply his mind, satisfy that this reply is okay, then only he'll furnish information. Just because somebody is giving, it is not that PIO has no responsibility. PIO has a duty to ensure its correctness, completeness, relevance, everything. So this is very important. This is actually DOPT letter also very clearly told. Does not authorize him to designate somebody as PIO. PIO is a permanent setup. For a particular RT application, PIO cannot in turn redesignate some new officer as PIO.
Some information for the board level. Yeah, just sitting in different source. We are also asking to reply to the directly to the information.
Actually, sorry to say, but the railway board is mostly adopting a wrong procedure. When it is spread over.
What is correct? So many.
Yes.
Unfortunately,
sorry to say, but there is actually, sorry to say, but many applications are not dealt properly by the railway board. Because on a specific case, I still remember in Western Railway, after the MR's visit, there were some developmental programs announced. After some point of time, some social activists asked about the outcome of this one, implementation about this what you call assurances made by the minister. It purely pertains Western Railway, but when I was in South Central, it has come to South Central also. Not only South Central, the whole of the railways they have transferred it. What sense it makes actually? They're only, I must tell that they are using only their positional hierarchy, nothing else actually. So when pre-law it is spread over the zones and divisions, they must not reply actually. They must tell that you approach the consent zones or divisions. Of course, if suppose the zones or divisions are giving some compiled information, say outage or something, some information is there with the railway board, readily available, you give directly. If you do not have, you ask the applicant to directly approach the zone or division. Don't transfer it because we are also losing revenue. I will deal how to deal with such applications actually. Even if it is transferred also, it is to be treated as a separate application. We must ask for processing fees first, thereafter further fees. That is what CAC has told. Of course, in the second session, we'll see it.
But the board may say that they are not holding that information. Information available only in the territory.
Then they should decline it actually. They should not transfer actually. They should decline it.
They can decline it easily.
Because when from board it is getting transferred, we are not even bothered to collect the processing fees. Leave about further fees. We are not even collecting the. It has to be treated as an independent application. We'll come to that point, sir. There is a slide about it. We'll come to that point. And RTA request time disposal. Normally we know is that is 30 days. 30 days is not always. If it is affecting life and liberty, we have just 48 hours time to dispose of the case. And there are some extensions of the maximum limit. APIO, if he receives application, then there is 5 days extra for disposal because he has to transmit to the concerned PIO. If APIO is receiving the application, there is 5 days extra. Similarly, if transfer happens from one public authority to another public authority, again, there is another 5 days extra. But please mind it, it is only between the public authorities, not when PIO is asking information to the deemed PIO. In such cases, there is no extension. It is within it is intra-office or something like that. There is no extension, but in these cases, when PIO to PIO transfer is happening, suppose senior DCM transfers to CMS or something like that, we can treat that both are different PAs, public authorities, and we can ask for it. Then the fifth point is if the interest of third party is involved, we have a higher time limit of 40 days. Actually, if you strictly going by, it must have been or should have been 45 days, but unfortunately, they have given a time of 40 days because within 5 days, PAO is supposed to write to the third party. So 5 days gone. And 10 days time given for the third party to reply. So normal course, it is 30 days for replying. So if you add up these three, it should have been 45, but unfortunately in the act, they tell an upper limit of 40 days only. So that is another time limit. Then we talked about this schedule to organizations referred in section 24. Schedule to organizations are not fully exempted from RTA purview. Those related to corruption and human rights violation, these organizations also are bound to reply. Schedule to organization like BSF, CBI, whatever it is there, RAW, many things are there. Revenue intelligence and all those things are there. They are also bound to reply to the RTA application if it is pertaining to some corruption or human rights violation. And as far as human rights violation are concerned, the reply should be furnished after taking the consent, permission of the CIC by the PIO within 45 days. Here the procedure is different. Normally PIO furnishes the information directly, but if it is scheduled to organization, first they will seek the approval of CIC. After getting the approval of CIC, within an overall time limit of 45 days, they will reply to the applicant. So here prior permission of CIC is required. This is a strange procedure actually. Then suppose if the information is not given within the time limit, it is a deemed denial. No reply at all from the PIO. It is treated as deemed denial. And suppose the applicant is informed about the time limit. Sorry, about the further fees to be paid. The time taken by the RTA applicant is exempted from the purview of this 30 days limit. In other words, suppose PIO receives an application. On the 5th day, PIO is writing to the applicant, you need to pay another 100 rupees because there are 50 pages involved. Once the PIO dispatches the letter, that timeline, 30 days timeline freezes there. It stops there. It will not be counted beyond 5 because 50 days is dispatched. Now suppose the applicant is taking 2 months, nothing to worry. 2 months will not be counted. From the date the PIO receives back further fees, again the clock ticks. Again the clock starts running. Means PIO will have still another 25 days from the date of receipt of the further fees because he consumed only 5 days initially. So the period, the interregnum will be freezed. There will not be any counting of the intermittent period actually. It will be freezed. Then another very important thing, please do not send the application by certificate of posting or ordinary posting. As per railway board letter, I've mentioned it there. We need to send only by registered post or speed post. There is no other option. Either speed post or registered post. There is no other alternative. And I also please suggest you that you please take article tracking printout and keep in the file. After say we are sending by speed post or registered post, after a week or something, it must have been delivered in 3-4 days. It gets delivered. Please go to the India Post website, take a printout of the tracking, keep it on the file because we cannot tell which document will come to our rescue. So please keep it on a safe side. I'm not only telling about RTA cases, all the cases. When an office is sending some registered post or speed post, please have a tracking, take a printout and keep in the concerned file. Whether it is DR proceedings, any notice sent to a contractor, whatever it is, please have a tracking because after 3 months you will not be able to track it. Up to 6 months, Postal Department may provide you if you apply to them. They will provide you proof. But beyond that, even they will not give information. So for our safety, any article, I'm not only relating to RTA cases, but any cases, if you are sending anything by registered post or speed post, please keep a article tracking record, print out and keep on the consent file. So just I have put this in a tabular form for easy understanding. I need not repeat. We have already seen it actually. We'll rush to the next one. Very important. So as I already told, information should be normally furnished, except those who are figured in section 8 and 9. Section 8 and 9 give some exceptions. Other than that, we need to furnish the information. Section 8(1) has 10 exceptions, A to J. A to J. 10 exceptions are there. I have highlighted one letter with red ink, red color. Font has been made into red color. That is just to remember that subsection, because A for affecting, B for forbidden, C for breach, D for trade. You will just see the left side. So that particular alphabet, just something like a mnemonics, I made one alphabet in a different color just to connect easily with the subsection. So E for relation, like that. F for foreign government. So that is only one word, you may find it differently colored. So first A, we have 2 limbs are there. First is affecting sovereignty, integrity, security, all those things, economic interest of the state or relation with a foreign state. That is one aspect. And you please see the second limb, leading to incitement of an offense. That is actually totally unconnected matter. A has a second limb leading to incitement of an offense. So in that case also will not furnish information. Then expressly forbidden to be published by courts or tribunal, which may constitute contempt of court. Here also we must be cautious. Mere pendency of a litigation, some cases going on, that cannot be a reason for denying information. There must be an express order from the court not to part with information. Only then we'll deny the information. So if in the absence of any such direction, we need to give information even when court cases are pending. Let us be very clear on it. Third one is breach of privilege of parliament or state legislature. D, commercial competence, trade secrets, IPR, etc. E, we have fiduciary relationship. Fiduciary relationship, we have another slide, we'll see in detail. F, confidential information obtained from a foreign government. All these are exempted. G for endangering life or physical safety of any person, or identify the source of information given to the law enforcement agencies for security purposes. H for impeding the process of investigation or apprehension or prosecution of offenders. Here we must know that investigation also includes departmental proceedings. If disciplinary proceedings are pending, that is also treated as an investigation. Please don't think that it is only limited to police investigation or something like that. Even DR proceedings, inquiries proceeding pending also is treated as an investigation. Then lastly, we have cabinet purpose. Sorry, I for cabinet purpose, etc. But once the decision is taken, even they should be revealed. J, actually I have deliberately put per journal instead of S, just to remember it. Actually it should have been personal information having no relationship to any public activity or interest, or which will cause unwarranted invasion into privacy. So these are the 10 exemptions, and please go through the proviso below that. The information which cannot be declined to Parliament or state legislature should not be denied. This information should be, if it is to be given to the Parliament or state legislature, we need to furnish it. And court ruling says that this particular proviso applies to only J, not to all. The need to furnish information which is required to be given to Parliament or state legislature, that applies only to section 8(1)J. That is what a court has ruled, not to all other subsections of A to I. Only for J this applies. And lastly, we may see one important thing, rider. In the event an application is seeking information about an occurrence or event happened, say 30, 40 years, we cannot seek protection under section 8 except A, C and I. That means the information which are covered under A, C and I survive forever. That immunity is permanent. Rest of the sections we cannot claim after 20 years of occurrence. What I mean, I will make it clear again. Suppose there is a charge memorandum or something. It is an investigation. It was over by 20, 30 years now. We cannot tell that it is covered by H because it is beyond 20 years. Beyond 20 years, only A, C and I you can apply. Subsections A, C and I only can apply beyond 20 years. If the matter is related to beyond 20 years period, other exceptions have no application. That is what is the rider is telling. Section 9 is actually about copyright. Practically in railways, we do not have any application about it. Copyright subsisting in a private person, that is exempted. Then section 24, as we have already discussed, section 24 accept charges of corruption and human rights violation. Other information are exempted. They need not furnish information. Which are the organization covered under schedule 2 of the RT Act. And there is a provision which says that is 8(2) and 3. 8(2) says that if the PIO feels that the public interest is outweighing the protected interest. Protected interest means somebody's personal information, something related to a particular person or something. If the public interest is huge, it overweighs the protected interest, then notwithstanding any exemption under 8(1), he can still part with information, he can provide the information. Though there are provisions from 8(1)A to J, if the PIO feels that the particular RTA application has big public interest, he can still give information, overruling the application of section 8(1)A to J. That is it. Of course, 20 years we have seen already. Is there any other ground other than this section 8 and 9? Actually, Act says only section 8 and 9. But there are many exceptions which are court derived or CAC derived occasions are there. What we have seen, section 8 and 9 are confined, limited only to the Act statute, what statute is telling. But there are many grounds which have been created over a period of time by the courts or by the Central Information Commission. We'll have it, go through it. Suppose something is not coming under the definition of information at all. Section 2F defined information, but something is not coming under this information definition. Speculative queries. Suppose somebody is asking when is Shaji going to get his promotion. It is only speculative query. There is no document related to it. Somebody is asking some purely interrogative question. There is no document relatable to it. So this will not be coming under the purview of section 2F. When it is not coming under section 2F, where is a question of giving information? So that is one thing. Another thing is priced publications. Suppose government agency has published a book, suppose 100 pages. It is costing say 300 rupees. 100-page book, it is costing 300 rupees. Priced publication. Somebody may feel that if I apply under RT Act, I may get at 2 rupees per page. So 100 into 2, it is coming to 200. I can save 100 rupees. Somebody may feel it. But CAS has already ruled that priced publication is not anymore held by the public authority. It is in the public domain. So he need not furnish it. Let him buy it. At the rate indicated there. So priced publications need not be given. Then the information possessed or supplied by the RTA applicant. Suppose RTA applicant gives some information during the course of some activity. Subsequently, suppose he is asking for the same information, it need not be given. What CAC has ruled, we will see later. CAC has told only he has to be blamed if he has missed it. He need not furnish it again. Information related to complaints, inquiries, etc. Under Section 16 of POSH Act. Section 16 POSH Act, Prevention of Sexual Harassment, there is a prohibition of parting with information to public, press and media. So other than the complainant and respondent, nobody is entitled to get any information in such cases. RT Act will not survive here. Section 16 will prevail over the RT Act. Some slides you may see that something has been struck through. I am retaining it because it indicates the changed position, how things got overruled over a period of time. Here you may first see on the 5th item, information available under the statutes, certified copies under Supreme Court or High Court rules. First they told such things cannot be accessed through RT Act, they need to apply through the High Court rule or Supreme Court rule. Thereafter the Supreme Court has changed its position, that what is in reading. They told in this company secretary's case that existence of 2 avenues is not mutually exclusive and it is up to the candidate to choose either of the routes. So actually he was asking the examination paper, he asked in the RT Act because the company secretary's rule was cost was very high, some 100 rupees or something. So he wanted to avoid it, somebody applied. Then Supreme Court told no, it is for the party to opt between the 2 avenues available. But unfortunately, I feel that is unfortunately, Supreme Court has again had a flip-flop and subsequently, it was in 2019 that reading. In 2020, they again changed their stand and told that when some other rules or statute is providing for parting with information, both will coexist and the party needs to apply under that particular rule or statute. One cannot access through RT Act. So that is the latest position of the Supreme Court. Then Section 7(9) exemption. Actually, Section 7(9) there are controversial or conflicting judgments are there. Section 7(9) says that if the information is sought for in a particular form, to the extent possible, it should be given in that form, unless the resources of the public authority is disproportionately diverted. Suppose some information is only available in a electronically stored form. We have to take printout, huge printouts, say running into hundreds or thousands of pages and give it. It may require manpower, all those things. So it diverts our resources. In such cases, we need not go for it. We can tell the party that no, it is available in electronic form, you take it. Or suppose something is available in hard disk, hard copy, paper, books or something. We cannot make it, scan it, combine, merge it and make it into a single document, write to CD and give it. That is not required. If it is in hard copy, we will tell no. It is available in hard copy, you do it. You take it in this form. So to the extent possible, supply in the form asked. If it is not possible, then in a particular ruling, CAC has told that Section 7(9) can be invoked to decline information. But same CAC told in another case that no, it cannot be a ground for declining information. So conflicting orders are there on Section 7(9). Then 7(1) RT Act not addressed to the concerned PIO. This is actually Railway Board's case, GL Maurya versus Railway Board. In that, actually, CAC has reprimanded the chairman, saying that why did you reply at all? It was not addressed to the PAO, it was addressed to the chairman Railway Board. You should have never replied at all. So if it is wrongly addressed, we can decline it. That is one thing. Then repetition of RTA request. Suppose somebody, Mr. A is asking for some information 1, 2, 3, 4. After some time, again same A is asking same information 1, 2, 3, 4. So when an applicant repeats the same application after some point of time, then it can be declined under principles of res judicata. Res judicata means what is decided between two parties already by an authority. It cannot be again re-agitation because there should be a finality of things. Then advocate filing RTA request. Advocate filing RTA request is on the face not permitted. Unless the advocate is having the wakalat or authorization from the party. So RTA request by an advocate on behalf of the client is not permitted. Let us be very clear. Suppose Mr. X advocate is asking, it is fine if it is for him. Just because he has indicated that X is advocate, we cannot decline. But Mr. X advocate asking for Y, his client, then not permitted unless Y authorizes X, the advocate, through a wakalatnama or authority. That is what CAC has told. This is 10th one is very useful actually practically. A current litigant need not be given with information. This is Milap Choraria case. Milap Choraria case. Milap Choraria case, they told Milap Choraria was having a litigation with the concerned department. And what the CAC justified is that government has no access to your records or your preparations and all those things. And it will be unfair if we allow you to access the government's correspondence, etc. in this regard. Because that will reveal the defense in advance to you, understand the weaknesses, etc. So that is unfair. So we will not give information in such cases. So in the event, suppose some litigant is applying, we can seek exemption under this particular ruling. 11th one is unsigned application. This is applicable only for hard copy. Online there will not be any signature, but we need to furnish information. So hard copy, if it is coming as unsigned, we need not then resort to section 7, 9. We have already seen. Priced documents we have already seen. Priced documents or books we will not give information. Form of disposal. This we have just discussed. If a party is asking in a particular format, please give it if it is possible, unless it is going to disproportionately divert the resources. But the CAC has told in some other cases that just because information is not available in a particular form, don't deny it. Offer in the form available. Suppose I am asking some information in digitized form, but whereas in the field or in the office, there is only hard copy. Just because only hard copy is there, the CAC cannot, PAO cannot decline information. PAO should intimate me that, no, Bhaiya, it is available only in this form. You please check in this form.
The data it has been in Excel.
No, sir. We need not have to compile actually. We will not compile. For his sake, suppose we have seen applications wherein the RTA applicant himself gives some tabular form and all those things, some pro forma and all. Even no, we need not give. Anything relatable to an available document or information stored in a system, only that much. Let us not compile for him or make in the way he requires it. It is not required at all. Now, how to deal with RTA applications? What are the possible requests, possible methods of dealing? One option is to give the information within the permitted time. Giving the information, that is first option. Second is rejecting the information, duly quoting something from section 8 or the other exemptions. And third option is transferring from one public authority to another public authority. Thereafter it becomes a transferred authorities responsibility to reply for the RTA application. Another option is PIO can seek the assistance of a public information officer. So another officer working under him, and he will become deemed PIO, get information from that deemed PIO and supply under the PIO signature. Deemed PIO will not sign. PIO only will sign. And if there is no response to the application, it will be treated as deemed rejection. And if the timeline is breached, the penalty is rupees 250 per day, subject to a maximum of 25,000. So this is a penalty under RT Act. Each day of delay will be penalized with rupees 250, subject to a maximum ceiling of rupees 25,000. But here also one thing very sure I wish to put before you. It does not necessarily mean that this per day calculation should be always done. In other words, token penalty also can be imposed. Suppose there is a delay of 50 days. So 50 into 250 may not be there. Instead, CAC can tell I am imposing a penalty of rupees 1,000 or 2,000. That is also possible. We'll see.
Party or
No, it will go to the CAC. Normally they will tell take DD. He'll address the concerned salary drawing officer or higher officer to deduct from the salary of the PAO and send to them. It goes to the ministry, sir. This is very important actually, and I am sure that nobody is disposing RTA cases in railways in this particular proforma. This is a proforma prescribed by the railway board. This is a proforma prescribed by the railway board. Please do follow it. We may be disposing in a better form, but at least ensure that these ingredients are there while we are disposing of the applications. This is a proforma. I am repeating it. This is a proforma given by the railway board. Please dispose of only in this one. Anything more is all right, but don't miss out anything from this one. Probably we may not be adding email, but railway board say proforma says email ID is required. First appellate authority, PAO, etc. So whatever is here must be the minimum ingredients. If you are disposing in a better proforma, it is all right, but please don't miss out any information from this one. And as far as certified copies are concerned, it need not be signed by PAOs. It can be signed by any other gazetted officer, junior officer. That option has been given here. Now my question, one doubt. Suppose there is a huge information asked. With all my efforts as a PAO, I am realizing that it is not possible to meet the timeline of 30 days. What to do then? What is option? Act is not telling anything. Act, there is no, it is a strict guideline, 30 days only. But there was a CAC case in which the PAO replied to the party saying that we will not be able to meet the timeline. Please excuse us, whatever it is, it requires, because of the volume of the information, we may require more time. And CAC appreciated it and did not impose any penalty. So as a, what you call, face-saving performance, we can go for interim reply. Though there is no provision in the Act, interim reply can be given. CAC observed, you can see the last one. It is not wholly logically to expect that all information, irrespective of its nature or volume, could be collected, collated, or transmitted within 30 days. So CAC has realized that this is a ground reality. Even though the Act is telling only 30 days, CAC very well identified that it is not possible to reply within 30 days always. So my sincere suggestion is, if the timeline is going to be exceeded, please send an interim reply. This will save us from penalty. Definitely, if there is an interim reply, definitely CAC will not impose penalty. That much I am sure. We are seeing the CACs, practically they will not impose penalty. So long as we are acting in a bona fide way, that is also there, not as a method to avoid or delay tactic. We are bona fide in our approach. Definitely, that interim reply will help.
When?
Anytime, sir. Just say 15 days, 20 days. Before the expiry of 30 days. Otherwise, it becomes an effort to only avoid penalty. Your bona fides will be proved if you are giving interim reply within the 30 days limit. After that, it becomes only a tactic for avoiding penalty. They may not appreciate it.
For letter, the reply can be dated on the last day also, or 30 days it has reached the party.
No, sir. Actually, here, this is also another gray area, but we need to dispatch, that's all. He may or may not reach him in that. 30 days is actually, once we dispatch within 30 days, that is enough.
What we do is only put back and that is over there. There will be some delay always.
That is happens, sir.
That's the problem.
But even then, actually, even that can be exposed, because suppose if that is backdated and what is the date of posting, they'll see. If the applicant is shrewd enough, he will see the date of stamp of the postal authorities, or he will track in the system with the number. So when it was booked, so you cannot claim that you signed 2 days.
Holiday, Saturday, Sunday, now that you signed the letter, but it can be delayed by 1 or 2 days, 14 days.
CAC will not go to that extent. I have seen actually. CACs are normally liberal. Very rarely they impose penalty.
If the district secretary, suppose if they are not able to give there is no valid reason, then we ask for extension.
No, sir. No.
Inform the party.
Because of the justification for interim reply comes only if we have a serious reason, because of the bulky information sought or something. We cannot just like that ask.
You can say it was received late, or maybe somebody was on leave.
No, sir. No such things will stand. Only because of the voluminous of information or some other difficulty in really collecting the information from field officers or something, you can just tell. Then this is another important thing, section 10, severability. Suppose some information is asked, an applicant is asking, say, 5 information under different heads in a single application. 3 are exempted. 2 are to be given. Section 8 will not apply for 2 information. The remaining 3 comes under the purview of section 8. So this 2 will give, duly informing him that 1, 2, 3 are not given because it is exempted or something like that. Even another occasion of severability, suppose somebody is asking a vigilance report or something related to public exchequer. Say, for example, how the railway vehicle was used by Mr. X. We cannot tell that it is personal information, because so long as it is funded by the railways, paid by the railways, it comes in the public domain actually. But here, suppose a vigilance case was there or something, to protect the identity of the vigilance inspector, we may blacken that portion who has written the report and give the rest of the information. If we are worried about the security of the safety of the vigilance inspector concerned, we can do that. There also we apply this severability clause. Means only some information is given out of this one, and we must make a mention under section 81J because it is personal information, or G, endangering the safety of the vigilance inspector. We are invoking section 81G, and the name and designation of the concerned officer who prepared the report is not furnished. So we are applying severability clause there. Section 10 we are applying and giving the rest of the information. Then comes very contentious issue of third party. Third party is widely misused and wrongly understood by many actually. We very frequently use third party, most of the times wrongly. So who is a third party? I have given a very simple definition. Third party means the world population minus RT applicants. Anybody can be third party except the RT applicant, including the first appellate authority or anybody, including the PIO, FA, all. So population minus RT applicant is what? Third party. The population includes the public authority as well. Now, what is third party information? Let us go to the next slide. I have just cited section 11 here. Kindly see the words in red color, red font. Public information officer intends to disclose. Again, the reading next is stating his intention to disclose, to be kept in view. So, what is happening in third parties? First thing, suppose some information, the applicant is feeling that the PIO is feeling that it is belonging to the third party. That in itself is not an exception. First thing, PIO should apply his mind and see whether section 8 is applicable or not. If any provision of section 8 is applicable, then the PIO need not ask third party. PIO has to bluntly and initially decline the information. If any exemption clause is attracted, decline the information. Don't even ask the third party. But if the PIO comes to a conclusion a tentative conclusion that the information sought is not covered by section 8.1 and he wants to release it to the third applicant, but pertains to third party, then only he will write to the third party within 5 days. There's a time limit within 5 days. He cannot sit on for undue time and then go for it. Within 5 days, a letter correspondence should go to the third party, saying that I wish to disclose, because he feels at the start that it is not covered under 8.1. He intimates that I am proposing to disclose the information sought. Please give your views. Reply. 10 days time is there for the third party to reply. If there is no reply, please don't wait for the reply. Or write reminders and all those things. He has lost his stand, that's all. PAO can take a decision to give the information because he has already come to a tentative conclusion that he needs to furnish the information. And kindly see, to be kept in view, even if the third party is objecting, it is not a veto. Third party has no veto power. It has to be kept in view, that's all. That is not telling that if the third party is objecting, please don't give it. No. It has to be kept in the view by the PAO. If it is convincing for the PAO, okay, he may hold it, he may not give the information. But if it is not convincing, the reasons told by the PAO, third party is not convincing, PAO will part with the information. That is what is told here. So let us be very clear. If a matter is related to third party, don't ask him if it is falling under section 8.1, straight away decline the information. If the PAO is of the opinion that section 8.1 exemptions are not applicable, then only he will intimate the third party that he is going to reveal the information. Please tell your version, whatever your objections. So overall time limit for disposal in third party cases is only 40 days. And the last one, fifth point, third party has a right to appeal. Actually, this is actually a very strange or useless provision in the RC Act, what I'm finding, because the way the information is given is different and this will not serve any purpose. After receiving the objection from the third party, PAO is not convinced. PAO is parting with the information straight away. There is no holding of the information. Notwithstanding the objections raised by the third party, PAO gives information. When the information has gone to the RTA applicant, what purpose it is going to serve by preferring an appeal? It is actually useless provision. Actually, the provision should have been like this: if the third party objects and the PAO wants to release it, hold for another 15 days, permitting the third party to prefer an appeal. In that case, it is okay. There is some meaning in the appeal. Here, what is happening? As soon as the reply comes from the third party, and if the CPIO is not convinced with the reply or his objection, he is giving the information. There is no further embargo or what you call impediment in parting with the information. He can straight away give the information. Once the information has gone to the applicant, what is the purpose going to serve by the appeal? Actually, it is a useless provision. I don't know why it has come, but it is there. First appeal. This is RTA, we have a three-tier mechanism. First, we will go to the public information officer seeking the information. If it is not furnished or partly furnished or wrongly furnished or something, then we escalate to the first appellate authority. After exhausting first appellate authority's channel, then we go to the CIC through a second appeal. This is a three-tier mechanism what we are having under the Act. So first appeal, when we do not have any reply or we are not happy with the reply, then we escalate to the first appellate authority. Timeline to prefer first appeal is 30 days, and first appellate authority has a timeline of 30 days for disposal, extendable up to 45 days. That means another 15 days can be extended, provided there are recorded reasons indicated. Only if there are recorded reasons, there can be further extension up to 45 days. And delay can be condoned by first appellate authority. If there is any delay, it can be condoned by the first appellate authority. As in the case of RTA application, here also there is no specific pro forma for first appeal. He will narrate that I applied online or whatever it is, my application date so and so. But so far I have not got any response from the PAO, and hence this first appeal, or he has furnished information, but for so and so reason, I am not convinced with the reasons adopted by the PIO for declining the information. So kindly look into the matter. First appeal, that's all. First appeal, no fees. Fees is only at the stage of application. Thereafter, no fees at all. Whether it is first appeal or second appeal, there is no fees at all. And one important thing, the last point is the burden of proof lies with the PIO. That means in an appeal proceeding, whether it is before the first appellate authority or before the second appellate authority, the burden of proof lies with the public information officer that he has rightfully declined the information. RT applicant need not tell anything, need not prove. Once any appeal is preferred by the applicant, it is burden, the onus lies on the public information officer that he has grounds, reasons to deny the information. So that is a concept here. Second appeal. First, I'm not happy with the first appeal reply, or there is no reply from the first appellate authority, then I naturally escalate to the CIC through second appeal. For preferring second appeal, there is 90 days time limit. Earlier we have seen 30 days. Here in this case of second appeal, we have 90 days time limit. 90 days time limit. How to calculate 90 days time limit? Suppose on 1/1/2022, I am applying an RTA application. Suppose let us assume that it has reached on 5th January, it has reached the PIO. Reply over second appeal preferred. Suppose on 1st March 2022, I preferred a first appeal. 1st March 2022, I preferred a first appeal. He is supposed to dispose in 30 days time limit, extendable by 45 days. So we will wait up to mid-March, mid-April, 1st March. So they say, for example, approximately 15th April, we'll wait. From 15th April, suppose there is no reply up to 15th April, from 15th April onwards, I have another 90 days to prefer second appeal. That is one scenario. Suppose first appellate authority is replying in, suppose say 10 days. 1st March I applied, 20th March I am getting reply, declining the information or upholding the declining done by the PIO. So 20th March onwards, I have 90 days. If no reply means from the end, 45 days, another 90 days. If I receive a reply from the date of receipt, I have another 90 days to prefer second appeal. That is what is mentioned here. Here also, still delay can be condoned. First appellate authority or second appellate authority, delay is always condonable. Here also, in second appeal also, the burden of proof lies on the PIO that he has rightfully denied the information. And here another drawback in the system is that there is no time limit for disposal by the second appellate authority. CIC can take any number of days, months or something. And presently CIC is taking more than a year at present. That is a present delay. Huge delay, huge backlog of cases are there in the CIC. Now they are taking more than a year. Last one, CIC's decision is binding and final. So under the RT Act, the third level, the apex level is CIC, and it is final and binding. So you may wonder what to do if it is you are not happy with the CIC's decision. Though in the Act it is told as final and binding, we can invoke the jurisdiction of the High Court and approach the High Court. Of course, after that we can go to Supreme Court also. So in normal avenue of things, CIC's order is final. Unlike RTA application of first appeal, second appeal has a pro forma. That is what is given. This is given as appendix to the RTA rules 2012. So this is a pro forma. So you can see from 1 to 11 points. And it is to be actually typed, printed or something, or neatly written. It shall not contain any indecent language or abusive language. And advocate cannot fail. That we have already seen. Documents to accompany second appeal. RTA request should be there, its reply, if any, should be there, first appeal should be there, first appellate order of the first appellate authority should be there. Any other document, if you are relying, suppose to prove our point, say some other citation or something, we can give other orders or documents along with this one. Then index, on top of it, we should keep an index. Page 1 to 3, RTA application, 4 to 5, PIO's reply, 6 to 8, first appeal, 9 to 12, first appellate authority. So like that, there should be an index, and there should be certification that the matter has not been filed previously before any other authority, or is presently pending before any other authority. This undertaking should be there. Then CAC's powers while deciding the second appeal. There are many things they can, if any particular organization, public authority is not having PIO, they can nominate PIO, they can provide access, and they can ask the public authority to change their way of maintaining the records, updating, etc. They can order for training of the, suppose somebody is poor, when they are feeling that somebody is poor, they can ask that the PIO affairs should be sent for training, all those things. Then annual report on proactive disclosure. Section 4, there is a requirement to give the information on its own. They can ask a report on it. And B, 19(8)(b), compensate the complainant for any loss or the detriment suffered. So this is a provision enabling the CAC to give compensation for the RTA applicant. By wrong denying, if suppose RTA applicant has been visited with some inconvenience, difficulties or loss, that can be compensated by the CAC through this provision. Then C is impose any penalties. Penalties we have already discussed, 250 per day, subject to a maximum of 25,000. So they are empowered to impose penalty. D, of course, they can reject the application also. In the event if they are planning to impose a penalty on the PIO, they need to give a show cause notice to the PIO, get their response to it, and then decide on it. And in section 20, you will see not only penalty provision, there is a provision to recommend disciplinary action against the PIO. But if you see that both provisions for disciplinary proceeding as well as penalty, the only difference between these two is there is an additional word regarding disciplinary proceedings, persistent breach. Remaining the entire provision is same. Only the additional word for recommending disciplinary proceeding is persistent breach. If the PIO is doing persistent breach, then only they are supposed to recommend for penalty. Then we'll see penalty when attracted. Section 21 says, without any reasonable cause, if the PIO is denying the information without any reasonable cause, refusing to receive application or breaching the timeline or malafidely denying the request or giving incorrect or improper or misleading information, or the information itself is destroyed and obstructing in any other manner. So all those things may attract penalty. Penalty we have discussed also, 250 into maximum of 25,000. Token penalty is permitted. These are the rulings in which CAC has ruled that, and even Delhi High Court has upheld it, saying that token penalty is very much permissible. It need not be, we need not go arithmetically 250 into the number of days. Token penalty is also possible. Challenge to CAC's order. We have just told writ is the only scope. Earlier, when the regulations were in force, there was a provision by the Chief Information Commissioner to review it. There is no point in talking now. That provision is not there. That is why I have stuck to it. So review provision is not there. Now only the writ jurisdiction by the High Court. Implementation of CAC. Suppose CAC has given an order and it is still not implemented. The aggrieved party has to go to the CAC, not to the High Court or something. Go to the CAC saying that this has not been completed. Suppose CAC has told directed the PIO to give information in the next 15 days free of cost. Still the applicant is not getting the information. He can again approach the CAC, bringing this. He should not go to the High Court. That is what High Court has told. They should not go to the High Court or something. They must approach the CAC only. Now, chapter 6(5) we have 18, 19 and 20. The difference between section 18 and 19. Section 18 is a complaint. Section 19 is a second appeal. In section 18, the only possibility is imposition of penalty. Under section 18, no direction can be given to part with information. Whereas in section 19, the CAC can order compensation, direction to give information, all those things are possible. But in 18 only, penalty to be imposed or not, no direction can be given to furnish information to the applicant. This is what Supreme Court has told in state of Manipur case. Next slide will make things easy for understanding. I've compared section 18 and 19. Here in section 18, the scope is narrow. As I told, it is only limited to impose penalty or not. Whereas section 19 is second appeal is broad. Section 8 is supervisory in nature. Whereas section 19 is applied jurisdiction. Under section 18, there is no question of granting any compensation to the complainant. But whereas if it is a second appeal under section 19, CAC can compensate for the detriment suffered by the applicant. And next, access to information, no. Under complaint, there is no access to information. But whereas under second appeal, access to information also will be ordered. As far as complaint is concerned, a party can straight away approach the CAC. There is no need to exhaust first appeal. He is giving a complaint. But in the case of second appeal, only after the exhausting of first appeal channel, a party is permitted to approach the CAC. You may wonder then why this complaint is required. Suppose I will tell an example. I applied for some information. The PO has furnished information fully. I'm totally happy with the information furnished, but only my grievance is that he has taken 60 days instead of 30 days. There is a delay by 30 days. So I want to agitate against it. So there is no point in giving first appeal because I got the information. Then in such cases, I can straight away go to CAC saying that, complaining that under section 18 that I have not got the information on time. Please take up the PAO. So that is the difference, practical application I'm telling. Then time limit. As far as second appeal, we have already seen it is 90 days time limit is there for filing second appeal. But whereas complaint, there is no such time limit. At any point of time, one is permitted to apply. And if a complaint is filed under section 18 subsequently, it cannot be changed into second appeal under 19. So once a complaint, it is always a complaint. If it is section 19 second appeal, it is always going to be second appeal. It cannot be interchanged. Now we are coming to the end of RTA Act provisions. 22, 23, 24 are very important. 22 is actually says that it has a shall have effect notwithstanding any inconsistency with Official Secrets Act. Non-obstante clause means if there is something which is not or which are conflicting with the provisions of RTA Act, the provisions of RTA Act shall rule over the other provisions. That is what is meant by section 22. And in section 23, it is ouster clause actually. Courts cannot entertain the matters which are to be dealt by the authorities indicated in the RTA Act. Say first appellate authority or second appellate authority, all those things. Courts cannot intervene. So it is ouster clause. Jurisdiction of the courts are exempted. Then section 24 we have already discussed. It mentions about schedule 2. Schedule 2 we have intelligence and security organizations. These are the provisions of RTA Act. Record retention. This is actually an important aspect. Information pertaining to RTA we need to keep for 3 years normally. There is a record retention schedule prescribed by the Department of Personnel and Training for various documents. A, B, C, D like that. There are various categories are there. Each document based on its importance, there is a specific timeline given. Till such time we need to maintain the record. In normal RTA cases, we will keep for 3 years. And if a second appeal having an important decision, such cases we need to furnish, we need to safeguard for at least 5 years. So C5, earlier it is C3, C3 for normal RTA cases and C5 for important cases. And file pertaining to RTA applications has to be permanently retained. There is no upper limit or something. Files pertaining, suppose where we make entry of RTA applications, that has to be permanently retained. RTA application 3 years, important RTA cases for 5 years, but the register where we enter the RTA cases, RTA application, that has to be permanently retained. So these are the requirements. And you may wonder what to do with other information. Suppose something has been asked, say for example, PME detail has been asked. Suppose as per the rules of record return schedule, PME details to be, I do not know actually what is the actual this one. Suppose some document, it needs to be retained for only 5 years. Let us assume that some document has to be retained only for 5 years. For the sake of, in anticipation of an RTA applicant, we need not retain such documents indefinitely. After 5 years, we'll destroy it. After 5 years, if some information comes, if an RTA query comes with relate to the documents which we already destroyed because the record retention schedule was over, we will only tell that now it is not anymore available with us, we have destroyed it. But here a very important thing, a word of caution, whenever we are weeding out the documents because the record retention period is over, we need to enter in the concerned register, obtain the approval, and this register should be kept permanent. Merely telling that record retention period is over, it is not with us, it is not sufficient. And same is the case with missing files also. Sometimes really some officers may miss the files, but CAS is very serious on it. Be very careful. If missing files, they are telling you fixed responsibility, file affair, whatever it is required, you need to be done. You cannot just like that come and tell that missing files, because if that is not stopped, the plea of missing files is not stopped, it will become a haven for any PIO who is reluctant to furnish information to take shelter. So CAS is very serious on missing files issue. Missing files cannot be, that plea cannot be taken unless we fix responsibility and all this. They will not accept. So if missing files, they are asking immediately file affidavit. PO has to file affidavit, then there will be serious action on it. So missing files not permitted. So please keep a record of record destruction. Record destruction, document destruction, we must have a permanent record. Suppose after 5 years, somebody is asking 10 years, which we kept only for 5 years, we can show as per this record, we destroyed it. It is not anymore. CAS will be happy, there will not be any problem, but without having an entry, please don't destroy any records.
Last time will say that it's all misplaced or something.
No, sir. It is possible. That is practically it is. It happens that you might have misplaced. But whether you use the word misplaced or misplaced, missing, whatever it is, you are liable. Actually, they will not agree for it. Deficient scripture.
It so happens that the material is not available on the file. No information about the so it's not on the record, not in black and white printed. But the information is not to us.
No, I'm not getting you, sir.
Some information is not there. Not to, but it's not available on the record. Black and white printed form, it's not available. Information how you give and how you record.
We need not give. Information should be as per the definition. Documents, records, file, all those things should be in black and white.
It should be in physical form.
It should be in physical form, either in a computer or in a hard copies. Other things, otherwise it is coming as only somebody is asking to give your opinion or inform, particular advice or something.
What is the hospital working time? You will not have it, but all of us know after we start the part time, there is common question they'll ask. What time OPD open? So it's not available anywhere.
There must be circulars. Only thing, over a period of time, we might have lost sight of it.
I have not seen any records so far. Do you have records in the hospital? What time what happens is the order must have been there 10 years back. Maybe in this hospital, there is the part. They give you also right everything. There is some issue. The hospital open. Time is fixed. People will not keep on giving every year. Please not stop this from this year. Some reason there is a problem and they ask it. Unless that info is not available. I have not seen anybody. I will hold them. Let me see what is working out for area list. Very good. Office time. We have been following this on the time. Let's say we have to follow this timeline for that. So here's the probably has been, I don't know. If you ask me where is the file, then you give the file is not there. So the correspondent somebody is asked to raise, that's why you got it. So even that time also.
ഇനിയിപ്പോ ഇതൊന്ന് ഷെയർ ചെയ്യണം. അടുത്ത കേസ് ലോസ് ഒന്ന് ഷെയർ ചെയ്യണം. ഞാൻ അത് ക്ലോസ് ചെയ്തു പഴയതിന്റെ. ഒന്ന് എടുക്കാവോ അത്?
തീർന്നായിരുന്നു
അത് തീർന്നു. അടുത്താണ് എടുക്കണ്ട. ഇതാണ് കേസ് ലോസ്. ഷെയറിംഗ് ആണോ ഓട്ടോമാറ്റിക് ആയിട്ട്? അല്ല, ഇത് വേറെ, ഇത് ഇവിടുന്ന് വരുന്നുണ്ട്. അത് അതിനകത്ത് ഷെയർ ചെയ്യുന്ന ആവുന്നുണ്ടോ?
അറിയില്ല. ഇത് ഷെയർ ചെയ്യണം അല്ലേ?
ആ, ഇത് ഷെയർ ചെയ്യണം. Yes, sir. Ah, yes, sir. Ah, definitely. Anybody can ask.
Yeah. Is it possible to know how many are watching?
Share ആണല്ലേ? അതെ, കേസ് ലോസ്. Okay. Right.
How do you know how to someone check it?
So now we'll go to the second session about case loss. This will be more interesting as far as practical aspects are concerned.
Meeting now, my topic is not.
Now whether okay.
My topic has come now.
I see.
Safety meeting.
Right. No problem, sir. Now we'll go into the second half. This covers actually case loss of practical aspects. Can a company file RTA request? We have just had a passing remark this one. The company cannot ask for information. Only natural persons can ask. As we have already seen, citizens or persons, not anybody else. Yes, sir. If anybody is there, they can ask doubts. No problem. There are many rulings about company filing RTA requests. In Deva's case, they are very clearly told that a company cannot file RTA requests. So it is only for natural persons, not for companies. But suppose somebody is merely indicating as director or something, but not asking on behalf of the company, then we need to give. Just because some designation is indicated, we cannot decline the information. Unless his intention is to ask for the company, we will give information. Merely specifying the designation will not bar providing the information. Then another question is, sometimes we may have a doubt whether a citizenship need to be proved, because the RT Act is basically for the citizens. Citizenship need not be proved in normal cases. Only when the PAO has a genuine doubt about the issue, then he may ask to provide citizenship. Otherwise, citizenship need not be proved.
Your voice.
Usage of letterheads. There were cases when officials, especially government officials, also asked information under the letterhead. So what to do? So what CAC told is, just because somebody has used the letterhead, don't decline it. He is paying from the pocket. He is asking in his individual capacity. Though he has used letterhead, please furnish information. So letterhead, mere asking letterhead in itself is not a cause for declining information. I am actually rushing through this one because we have almost 79 slides. We'll mostly go only through the headings. Once I tell the heading, you will get an idea about what is to be done. Can an advocate file RTA request? No, we already discussed, unless the advocate is producing a wakalatnama or proper authority from the concerned person. Fortis hospital case is a very good one, but we'll skip for it. Suppose an RTA applicant is asking for inspection of documents. Then now the question is whether he can be permitted to take photos or videos. In a particular CAC ruling, they told both are permitted. Videography is permitted, photography is permitted during the course of inspection of documents. So that is a ruling by the CAC. Then assistance. What assistance can be given? In the event, suppose differently abled persons or something, or illiterate persons are there. For them, we need to give assistance. What sort of assistance is not clear, but at least we must help him to get the information. API was role. As you have already told, API was role is only to collect the applications and appeal and transmit to the concerned appellate authority or RTA reply in same language that we have already covered. RTA reply should be given in the same language. RTA only the RTA applicant has the option to apply in English, Hindi or regional official language. But CAC, the PIO cannot use any other language. You must reply in the same language. That is what CAC has told. Then wrongly addressed applications. Wrongly addressed applications need not be replied. That is what Railway Board has told, especially, this is what CAC has told in a Railway Board case. Maurya versus Railway Board, they very clearly told that wrongly addressed application you need not punish because under section 6.1, it is a duty of the applicant to send the application to the concerned public authority. For the same reason, transfer also may not be required to another public authority. If the information is lying with another office, department or somewhere, we need not transfer it also. This we have already discussed on documents. Suppose somebody has applied then some information and in future he is asking same, we need not give because it was information given by it. Okay, the soundness of the decision is a different issue, but this is what Supreme Court CAC has told. Whether penalty is mandatory? No, that is what High Court CAC has told and upheld by High Court. So penalty is not always mandatory. It may or may not impose penalty. Let us see the reasoning given by this one. Merely because the CAC eventually finds that the view taken by the PO was not correct, it cannot automatically lead to issuance of a show cause notice under section 20 of the RT Act and the imposition of the penalty. So just because the decision taken by the PO was wrong, as ruled by the CAC at a later stage, that in itself will not lead to a penalty. Penalty is possible or likely to be imposed only if the CAC feels that there was a deliberate intent in declining or delaying the information. Otherwise, penalty is not mandatory. Can first appellate authority be penalized? No, is the answer. Because as per the Act, the penalty provision is only applicable to the PIO. First appellate authority is safe. But of course, we have seen a odd case that also we'll discuss here. The reason given is very simple. The penal provisions are to be implemented or enforced only against the CPO, not against any other authority like the senior ranking officer or the appellate authority who decides appeal, because that is the provision of the Act. Why the penalty is only for the CPO? Because CPO is a custodian of the information and appellate authority is not the custodian of the document. He only decides, that's all. That is why there is a conscious omission of making the appellate authority liable for penalty under section 20. The section 20 never says about the first appellate authority. It has deliberately omitted to mention first appellate authority. So first appellate authority is immune from any penalty. But however, unfortunately, we have a case. In the RK Jain's case, the CAC has recommended disciplinary proceedings to be initiated against the first appellate authority. Personally, I do not agree with this order because it is a bad order, a wrong order is my opinion. After that, what happened, we have no information. But if it is challenged, definitely this order is not going to survive. But there was an instance of first appellate authority getting what you call recommended for this proceeding, but this action definitely will not survive in view of the statutory provisions what is contained in the Act. Whether transfer is permitted from one public information officer to another public information officer? No, it is not possible. It is only between the transfer is permitted only between the public authority to public authority, not between the public information officer to public information officer. In such cases, they can only forward it, but cannot transfer and avail that extra 5 days time. But in one particular case, Delhi Development Authority's case, I think, Delhi Police case, the transfer from public information officer to another public information officer was approved by the CAC because almost I think 200 PIOs were there. Because of that voluminous, the more number of PIOs in that particular case, CAC has not objected to it. Otherwise, transfer is only between the public authority to another public authority. Now, next question is whether it is possible to transfer the first appeal. The statute speaks about transfer of first appeal only between the, Act says only transfer of RTA application. It is silent on the aspect of transferring a first appeal, but CAC has told if the appeal pertains to other appellate authority, first appellate authority, transfer it. So transfer between the first appellate authorities are in order. Again, subsequently also, first they told in Mittal's case, subsequently they told in Jain's case also that it is permitted. So transfer among the first appellate authority is permitted if the information is held by the other officer. Now multiple transfers. Suppose railway board is getting an RTA query which is spread over zones or divisions. What to be done actually? They told as per section 6.1, RTA applicant is duty bound to apply only to the concerned public authority. He cannot send to a wrong authority and seek information. But our CAC told if it can be easily and inexpensively transferred, please do it. Say for example, electronically it can be transferred through email or e-office, whatever it is, transfer it. And in such cases, what is to be done by the recipient PIO? He should treat it as a separate application, ask for processing fees, and thereafter the full fees. First ask for 10 rupees, that is processing fees. Thereafter, whatever is for the copying charges, etc., to be additionally charged. So each application transferred down the line to be treated as a separate application. Information need not be collated or created. This is actually very widely quoted Supreme Court order. CBSE versus Aditya Bandyopadhyay. Actually, the case was regarding furnishing of answer sheet. Supreme Court has told the answer sheet has to be given. Section 81E will not apply. But incidentally, Supreme Court has made some very important observations. This is very widely quoted by many PIOs and first appellate authorities. What they told is, I'll just read out the read portion. But where the information sought is not a part of the record of a public authority, and where such information is not required to be maintained under any law or the rules or regulations of the public authority, the Act does not cast an obligation upon the public authority to collect or collate such non-available information, then furnish it to the applicant. Suppose if some information need not be maintained by the PIO, just because somebody is asked, he need not collect the information, compile it, collage it, and send to the applicant. That is not required. He need not give any information if it is not maintained in a particular form or no information is maintained about the particular issue. And the word advice and opinion appearing in section 2F is only the opinion and advice already kept on record. That means I cannot ask, what is your opinion in so and so issue? Nothing like that. Suppose as the PIO has already obtained on some issue, say some construction or something, some expert's opinion was asked. That is an opinion which is available on record. It is not that CPIO will speak his mind on some issue posted by the applicant. This is the difference. Advice or opinion means which is an expert given and already available on record. It is not that CPI will sit on the question, examine the question and give his opinion or advice. It is not the intention of the words advice or opinion. That is what court has told. And the last one is very wonderful, actually cited by told by the Supreme Court. The nation does not want a scenario where 75% of this staff of public authorities spends 75% of the time collecting and furnishing information to applicants instead of discharging their regular duties. This is what Supreme Court has observed. So that threat of penalty cannot be put on the head of PIO to get any information. Same CBSE, as I already told, evaluated answer sheets of exams to be given. But as far as departmental proceedings or selections are concerned, it is on a different footing. Earlier, they told that colleagues' answer sheets are not accessible for another employee through RTA application. But now it has changed. Personally, they told this is in 2018. Earlier one was somewhere back in 2010. Now they told exams conducted by UPSC, Staff Selection Commission, etc., stand on a different footing. In a departmental examination selection, an employee is eligible to apply for answer sheets of his colleagues also. Not only his answer sheet, his colleagues' answer sheet also need to be revealed. That is the present position now. RTA applicant is not a consumer. Actually, there are some Karnataka cases and all. I am not going into the details, but only let us know this much, that RTA applicant is not treated as a consumer. RTA application without fees and fees in unacceptable modes. Suppose we cannot accept revenue stamp or port fee stamp. Central government, we have some already what you have seen, only DD, banker's check, IPO, cash receipt, check and payment, this electronic transfer, only these things are permitted for central government. But suppose somebody is applying or no application fees, or somebody apply through, for example, stamp paper or something like that. Normally, as per the act, it need not be treated as an application under RTA. But CAC has taken a different view. CAC has told in 3 cases I have cited here, in that they told even if fees is not there, we need to give the information. And they have given a justification also. The justification is that the public information officer should consider such an application sympathetically and try to supply information sought by way of such an application. This is, they have quoted from the Department of Personnel and Training's letter. DOPT told that application without fees is not an application at all. But however, the PIO should consider such an application sympathetically and try to supply information. CAC has relied on this DOPT letter and told that even when there is no fees, you need to furnish the information. And another thing is, suppose the further fees is very low. Suppose somebody is asked information, it is only running into say 3 pages. We have to charge 6 rupees. Is it wise enough to spend 25 rupees for speed post, asking the party to pay 6 rupees? So they told no. Canons of financial propriety or something you can tell. So they told no. If the further fees is very negligible and the cost of collecting it is more than the further fees, please ignore it. That is what CAC has told. So if some information is very less in number of pages, please ignore the further fees. Repetitive RTA requests and appeals. Suppose somebody is going on giving RTA requests on the same topic and appeals also on the same topic, then they told principles of res judicata, consecutive res judicata, and other 2 legal maxims are there. All these things apply. Res judicata means an issue decided between 2 parties on the same topic by some authority. It cannot be again reopened or re-agitated. That is over. Res judicata applies. Consecutive res judicata means, suppose some ground should have been raised on the first occasion. Suppose I have a case, land dispute. I have raised before a court 5 grounds which are in my favor, though 2 other grounds were there. After raising the 5 grounds, I lost it. Then I realized that had I included these 2 grounds, probably I would have won the case. I cannot go to court with these 2 additional grounds and say that on these 2 grounds, please consider. No. Consecutive res judicata means all the 7 grounds I should have raised on the first occasion. That is consecutive res judicata. Whatever I should have raised on the first occasion should have been raised on the first itself. Some part meal dealing cannot be done. Here, Stacey has done a wonderful observation. Citizens do not have a right to repeat the same or similar or slightly altered information request under RT Act, for which he already got response. Such a repetition shall be considered as reasonable ground of refusal. So, if an RT application is repeated by the same person, please deny it. Then as far as queries, how to deal with queries? Somebody may ask questions. When am I going to get promotions? An employee may ask. It is a speculative query or interrogative query. Nobody can tell when one particular employee is going to get promotion. It is not related to any document. So in such cases, we decline information. But some queries are related to some document. For example, who is the inquiry officer in the major penalty charge memorandum issued to Mr. X? Here in this case, there is a standard form number 7, order of appointment of inquiry officer issued in the case of Mr. X. So it is relatable to a document. In such cases, we have to tell yes, as per SF7 number so and so, dated so and so, A was the inquiry officer in the inquiry against Mr. X. So we need to give information. Putting it in other words, just because some question has been asked, we cannot bluntly refuse it. If it is related to a particular or based document, only interrogative or speculative queries we can decline information. Now next query is information already placed in the website. Suppose under section 4, proactive disclosure, I place some information in the website regarding my organization, my department or whatever it is. An RT applicant is asking some information related to that particular item which is already placed in the public domain. Here, unfortunately, we have conflicting judgments of CAC. Some orders say that such information which has already been placed in the public domain cannot be anymore treated as held by the public authority or under the control. It is already gone out of his reach or control, and it is in the website. So such information need not be furnished. But CAC in some other cases have very clearly told that even if the information is furnished in the website, still we need to give the information under the RT Act also, notwithstanding the availability of the same in the website. File notings, we need not go, already we have discussed file notings to be given. And in vigilance cases, as I already told, apply section 10, severability clause, hide the identity of the vigilance inspectors or whoever it is there, and give the rest of the information if it is pertaining to public exchequer. Then ACRs, of course, now it has no relevance because now it has become APR and everybody is getting APR for their comments or making representation against it. Third party we will not give, others APR we will not give. Frivolous applications. Somebody has asked in a particular case, all the records, give me all the records of your office. Actually, many information may be required to be furnished, some may be coming under the section 8 exemptions. But in such cases, they told no, we will not give any information. The matter has gone up to CAC. CAC told it is a frivolous application. We have done the right thing by denying information. Just like as I told, no, 106 questions asked by somebody recently, railway factory case. My advice was, you please say that it is a frivolous application. Some information, but at 10 years, some 7 years, some 9 years. So frivolous applications need not be replied. This is very important. Reasoning needs to be given while declining information. Please don't think that citing a provision of section 8 is a reason. When you are referring to section 8, it means that you are only taking shelter under some clause, but reasoning is different. Reasoning and reference to sections are different. Reasoning means why, suppose I want to say that a vigilance inquiry case or something, I don't want to give information under section 820 because it may endanger the safety of the concerned vigilance inspector. So I cannot just tell that the information comes under the purview of section 820 and hence I am denying. Not possible. I must tell why 820 has an application. In other words, I must give brief reasons why 820 has application in that particular case. In other words, a sort of justification or reasoning is required. Don't merely quote the provisions of section 8. In addition to that, there should be a brief reasoning given as to why this particular exemption comes into play. That is required. We have already told, I had a passing remark on this one. Sub judice is no reason. If any court case is pending, we cannot tell that no, because court case is pending, we will not give information. Unless that particular court has prohibited parting with information. So mere pendency of a court case cannot be a reason for parting with information. Then litigant, we have already discussed Milap Choradia case. They told that, and subsequently reiterated in some other case also, that if a litigant is asking for information, the PIO is at liberty to decline the information. And investigation, the word investigation covers the disciplinary proceedings also. DR proceedings comes under the purview of the investigation. So if there is any pendency, we can decline information. Fiduciary relationship. Fiduciary relationship is actually normally normal courses, it does not come into play. It is coming under section 81E. Fiduciary relationship means somebody keeps what you call him under the control or guidance or expertise of another person, just like a doctor and patient or an attorney and client, trustee and beneficiary. All those things are actually here. One person has an option, himself place himself under the control of another person to get his advice or guidance, expert guidance. Only in such cases. Normally we sometimes misquote this one. It is not correct actually. I'm skipping most of the one because time is running out. Then medical treatments, one's own medical records are accessible. Section 81J cannot be invoked because section 81J may apply to others, but not to the same person. Then PF amount. PF amount of employees to be revealed, but after hiding address, contact details, etc. And next one is about attendance. Suppose somebody is asking whether your employee Mr. X was present on so and so dates. We need to give information because it is a public activity. Doing duty is a public activity. We cannot tell that no, you have nothing to do because you are asking third party. We may quote third party. No, it is not third party. He is doing a public job. It can be scrutinized. So attendance register has to be furnished. Tender documents. Tender documents, what the CIC has told us that once the tender proceedings, finalization, tender awarding is over, it has to be given. Not only that it has to be given, what they recommended is please place in the public domain so that those who have not got the tender will come to know why they have not got and why others have got, somebody else has got. That is what is tender documents. Then confidentiality. Can we claim a document confidential and seek exemption under RTAC? No, it is not possible. Confidentiality is not a ground under section 81. Section 81 has given 10 grounds. Only on those 10 grounds we can deny information, but we cannot label something as a confidential document and decline information. Charge memos, enquiry details, etc. need not be revealed. This is as per the Supreme Court's order in Girish Ramchandra Deshpande case. They told memos, show cause notices, sent punishment orders, movable, immobile property details, ITR details of an employee need not be furnished. Whether PIO can appeal against first appellate authority? Yes. Suppose first appellate authority is directing the PIO to furnish information. If the PIO feels that the order is not correct, he can prefer appeal. That is what the CIC has ruled already. First appellate authority also to furnish information, as I already told. Suppose PIO has got an application. The matter is purely under the control of first appellate authority. As an officer, he can seek first appellate authority to give information. So after that, PA will sign and furnish the information. PNR details. This is actually based on Commercial Circular number 34 of 2019. Earlier, the order was different. Now, this was issued 3 years back. Self-travel, RTA fees plus submission of ID proof. If somebody is giving RTA fees and submission of ID proof, his own travel details will be given, certified. For other passengers, not to provide unless consent from third party is required. I'm asking somebody's information. Railway will approach that passenger, ask him whether you are prepared to give If he is not giving consent, we cannot give. Actually, I am not in agreement with this particular commercial circular. We have different reasons. I think that over a period of time, CAC may quash this order. CAC will not allow, but of course, now so far this has not been questioned because third party, the concept of third party never involves any veto power for the third party. Suppose a lady passenger is there, some co-passenger has troubled her during the trip, or taking the modesty, whatever it is. She wants to know. At that point of time, she was so scared that she did not opt to react there, feeling further danger to her life or something. But after the end of the journey, she wants to deal with them. So she is asking. So suppose railway asks the same culprit, same person who troubled her, will he give consent? No, he will not give. So here this, as per this railway court of letter, only if the consent is available, it is not given. So what would suppose letter is coming as delivered, he is not replying. What should be done? Can we treat it as a no? So all these things are gray areas. Actually, this I am not, as a person, I am not in agreement with this railway board order, but of course, this rules the day now. If unless consent is there, we cannot part with the information. If government is seeking rupees 50 per PNR and official request from the department, and as far as courts and other agencies, investigating agencies are concerned, we will give free of cost. Missing files. I've already cautioned you, missing files cannot be an excuse. Unless we fix responsibility and all those things, the PAO will bear the brunt. So let us be very clear about maintenance of files. We cannot just like that tell that files are missing. Suppose the complainant or the appellant has expired. Earlier the position was that CIC used to close the case. Now they have very clearly told that case cannot be closed. CIC should give its order on a pending appeal or complaint. And if somebody is asking for personal hearing at the first appeal stage, CIC has ruled that such a hearing needs to be granted. And in some cases, we have seen at the appeal stage, the applicant asks for something more than what he originally asked. In such cases, we need not give the information at the first appeal stage. The first appeal shall confine or limit only to the original questions, original queries asked, not beyond that. Immunity. Actually, section 21, we have already seen. Section 21 gives some immunity. A general reading gives the impression that it applies only for the PAO or first appellate authority. But Kerala High Court has ruled that no, this protection is available even for the RTI applicant. In a particular case, Spices Board case, I think Spices Board case, lady officer has not got further promotion or something. She wanted information. While seeking information, she has written a covering letter making some allegation that I'm suspecting the transparency and I'm suspecting corruption also. So hence I want the information. The officers got offended with that covering letter, saying that how she can raise such an allegation. They taken her up under the dismissal proceedings pertaining to Spices Board. Then the lady officer approached the Kerala High Court. The Kerala High Court told that no, the protection given under section 21, immunity for the acts done in good faith, that extends even to the RTI applicant. You cannot take up the RTI applicant because of this immunity. So that is section 21. So I have rushed through and we have come to a conclusion. Any doubts we can discuss now. Actually, this is 2 days matter, sir. Actually, what the slides I'm having are almost 160, yes, 160, 150, 160 slides are there. This is intended for actually 2 days training, but we have to rush through. Now, any doubts? If anybody is there, we can ask. Anybody online? Any queries? Otherwise, we'll wind up. Any doubts? If I'm able to, I'll clarify. Otherwise, I'll get myself clarified and revert. And if anybody is in need of this PPT, please let me know the mail ID. I'll share it. I'm happy to share the PPT. Sir?
Your email address.
My email address is mk.shaji. mk. Sir, first slide, actually, but to get slide, I need your mail ID. My mail ID is there in my slide, the PPT, but to share the PPT, if anybody is requiring, sir, if anybody is requiring my this two PPTs, please let me know. My mail ID is mk.shaji, mk.shaji, @yahoo.com, mk.shaji@yahoo.com. And in the event, if there is any doubt, I am also always available over phone. I have a habit of even calling back from unknown numbers. So if I'm unable to attend the calls, I'll revert you. So RTA doubts and all, we can clarify, not only RTA, other legal issues also. My phone number is 92462 90550. 92462 90550. Please let me know if I am of some help somewhere in the legal field. Wind up, sir. Thank you, sir. We are closing the session. Thank you very much for joining me. Thank you.
Thank you very much, sir. Thank you. It was very, very elaborate and very nice, very useful. Thank you so much.
Thank you, sir. Thank you very much, sir.
Okay.